Hi muckers, welcome back to my YouTube channel. I hope you're all doing very well. I'm wearing my Chapel Roan inspired outfit right now. I have cowboy boots on as well. I'm very excited. I'm going to Chapel Roan tomorrow, and tonight I'm going to a Chapel Roan themed club night, which I'm so excited for. So I have a very fun 48 hours ahead of me, and then I go straight from there to LA. So the next couple weeks, the next month actually is going to be really crazy, and I'm going to be announcing two big projects in the next couple weeks. So keep your eyes peeled. I'm very excited for both. And yeah, welcome to today's video. If you're not subscribed, please consider. We're getting really close to 500K, which is mind-blowing. I promised I was going to go through this MrBeast document. So if you don't know what's happened, I've posted a video yesterday, but MrBeast and Amazon are now involved in a lawsuit because of the Beast games. And I actually have a copy right here of the court document, the lawsuit, and it's redacted at parts, but we're going to go through it and see what we can take from it. You know, there's a lot here. I see Rosanna Pansino is featured in it. There's a lot to go through. There's a lot that isn't redacted. There's a lot that is redacted. Obviously, it's for the privacy of the people that are speaking up because there are NDAs involved. But let's go through it. Let's go through it. I hope you're all doing very well. Thank you for choosing to watch the video, and let's go through it. Okay, so we have redacted right here. Now, this was filed very recently. This was filed on the 16th of September. All right. So we have the attorneys for plaintiffs, Superior Court of the State of California. So a class action complaint for failure to pay minimum wage. Number 2, liquidated damages for failure to pay minimum wages. Number 3, failure to pay overtime. Number 4, sexual harassment. Number 5, failure to prevent harassment. Number 6, negligent infliction of emotional distress. Number 7, failure to provide uninterrupted meal breaks. Number 8, failure to provide uninterrupted rest breaks. Number 9, failure to pay wages promptly upon termination. Number 10, failure to provide accurate and itemized wage statements. Number 11, failure to indemnify for employee expenses and losses in discharging duties. Number 12, unfair business practices. Number 13, false advertising. And number 14, declaratory relief. Jury trial demanded. Oh my God, wait, that's really interesting. A jury trial demanded. Oh wow, okay. So we have contestant number 1, contestant 2, 3, 4, and 5. So they are all California residents. Obviously, they are being referred to as contestant 1 to 5 out of the sake of privacy and also under NDAs. And then we have MrBeast Company, right? We have Amazon, and then we have NRB, which I guess is MrBeast 2024 LLC, Amazon. Okay, so a big lawsuit at hand. Wow. Okay. Wow, there is a lot going on here. Facts. The contestants engaged what appeared to be a thorough application and vetting process for Beast games. B. The contestant agreements that the contestants entered into with production defendants included and then redacted. The contestants were employees under California law, but defendants intentionally misclassified them to defendants' economic advantage. The contestants were not volunteers. The contestants were promised and received compensation in exchange for their services. The contestants had no autonomy. Defendants exercised complete control. The contestants performed work that was in the usual course and scope of defendants' business. The contestants are not customarily engaged in an independently established business of the same nature as the work performed for defendants. Defendants misclassified the contestants blank to avoid their employment obligations under California law and to wrongfully receive unearned tax credits from Nevada, which is really interesting. Defendants required the contestants to sign agreement with illegal and unenforceable terms, so basically NDAs, from my knowledge. And my knowledge is not great, by the way. I'm not great with reading these things. I'm just genuinely diving into this and interested to see what I can pick apart from it. And if you can pick apart anything else, please leave it in the comments down below. Defendants failed to provide a safe and healthful place of employment to the particular and collective detriment of the female contestants who suffered sexual harassment. Wow. The How to Succeed in Mr. Beast Production Handbook, which we've gone through, states that it's okay for the boys to be childish, and if talent wants to draw a dick on the whiteboard in the video or do something stupid, let them. Really do everything you can to empower the boys when filming and help make content. Help them be idiots. So basically this full concept of the boys club and the boys can do whatever they want. Helping the boys make content apparently translated to, and then we have redacted, Beast Games created hostile conditions where women were forced to endure the severe embarrassment and unfair disadvantage of, and then we have a redacted. Defendants made multiple false statements to the contestants in connection with Beast Games prior to the start of the competition. Defendants falsely advertised that the competition would have 1,000 contestants, then we have redacted, and this cut the odds of winning than what was originally advertised. So we're aware of this as well, that the contestants thought that it was just going to be 1,000 competing for the $5 million, but they ultimately found out that there was 2,000, and 1,000 of those were going to be on a MrBeast YouTube video, and 1,000 of them would make the show, which is what a lot of them didn't know. Okay. Defendants misrepresented that redacted. The Beast Games production was so void of standards of reasonable care that MrBeast allegedly offered to cover the contestants' therapy. Plaintiff's individual experiences. All right, class action, general allegations. All right, so we have, it's class action. And then cause of action, we have failure to pay minimum wage. And then we have what it's under. Liquidated damages for failure to pay minimum wages. And we have what it's under, failure to pay overtime. False advertising, unfair business practices, failure to provide accurate and itemized wage. So we went through this. This was the original list just with all of the like codes beside it for the law. Wow, and jury demanded is a big thing. Wow. All right, contestant 1, contestant 2, contestant 3, contestant 4, and contestant 5, collectively plaintiffs, individually and on behalf of the proposed class, allege introduction. Plaintiffs bring this action on behalf of themselves and a proposed class consisting of all individuals who were engaged as contestants in the Beast Games content production in, and then we have the information, redacted, obviously. Defendant production companies and Amazon shamelessly exploited the labor of approximately, redacted, people who served as contestants on the forthcoming $100 million Amazon MrBeast production Beast Games or production is what it will be referred to, which Amazon promotes as the world's largest live game show with the biggest single prize in the history of television and streaming. And now that's going to come back and bite them in the ass that they're really gloating about how big this is going to be if they're able to get them for mistreating the people involved, because they're gaining so much from it and these people who were involved are losing so much. The Beast Games entertainment value arises directly from the physical and emotional labor of the contestants who compete under pressure cooker conditions for life-changing prize money, with one person purportedly to win $5 million in the end. So that is the prize. Defendant MRB 2024 LLC is a production company believed to be owned in whole or part by James Jimmy Donaldson, the creator and face of YouTube MrBeast brand. Mr. Donaldson, aka MrBeast, is a 26-year, which the fact MrBeast is 26 is crazy to me. Like, no shade, but I would have put MrBeast as 36 rather than 26, and there's just so many reasons for that. Like, 26 years old just does not compete in my head with MrBeast. Like, that seems too young. Who, on information and belief, has the most YouTube subscribers in the world and is the first YouTube billionaire. I wonder if that's true. First YouTube billionaire. I mean, maybe, I guess. The MrBeast Entertainment Empire produces stunt philanthropy, which typically features MrBeast performing corporate-sponsored, attention-getting philanthropy for publicity. Wow, that's a crazy sentence. They really expose what it's really all about. Corporate-sponsored, attention-getting. Wow. The business model is essentially is that MrBeast performs giving away some corporate money, whether a lot of cash, cars, or even houses, to strangers or followers, and his corporate sponsors compensate him with even more corporate money. Ooh, shit. Okay, so they're literally calling it all out. Class action complaint. Defendant Amazon is on information and belief the unscripted television division of Amazon Studios, which reportedly was previously ran by Mark Burnett at MGM Worldwide Television Group before Amazon Studios acquired the division in the Amazon MGM merger. Amazon Alternative creates content for Amazon Prime streaming services, which boasts over 200 million paid subscribers, which is crazy. These two commercial giants, MrBeast and Amazon, partnered with production company defendant Off One Base LLC to produce Beast games, which would be filmed in and then redacted. Mr. Donaldson, who has publicly represented that all of MrBeast contendants get paid if they compete for just 5 minutes, gushed to his fans online, wow, they're really using all his words against him, gushed to his fans online about the biggest ever, bigger than ever scale of the Amazon-sponsored Beast games, stating that money was not a constraint, which is also going to come back and bite in the ass that he has gloated about that, money doesn't matter. Well, they're going to be like, oh, if money doesn't matter, then, pay contestant 1 to 5 for what you owe them. And that Amazon had given him all creative control and the ability to do whatever he wanted. Unfortunately, the supposedly MrBeast did not want to use the alleged unconstrained resources to provide fair wages or even bare minimum legal working conditions to the blank contestants whose labor comprised the core commercial value of Beast games. Instead, defendants employed superior bargaining power to coerce the contestants to sign, apparently the likes of NDAs with illegal terms and obligations, and also knowingly mischaracterized contestants, redacted, to avoid defendants' employment obligations under California law, which is a really big thing as well, that they're pulling this California law out. Let me put on some Vaseline. My lips are dry. Wow, this is crazy. All right. Defendants knowingly misclassified the contestants, redacted, in part to obtain a tax credit. Whoa! Whoa, 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 whoa! Defendants knowingly misclassified the contestants, redacted, in part to obtain a tax credit for $2,252,523. Whoa! From the state of Nevada, which contestants on information and belief would not have received if they had disclosed the production's actual labor cost, including the significant labor of blank contestants. In the budget, they presented to the Nevada Film Commission with their tax credit application. Defendants then induced blank to serve as contestants on their $100 million production based on a false representation that 1,000 people would be competing to win $5 million prize, announcing only upon the contestants' arrival, blank, reducing the contestants' odds of winning, blank, before the competition began. So basically that it went from 2,000 to 1,000. Defendants further relied on the misclassification as a false justification to avoid paying employment taxes and to spare the production the cost of implementing various employment protections required under the California law, including minimum wages, overtime, mandatory meal and rest breaks, worker compensation benefits, itemized wage statements, and timely payments of wage and reimbursements, amongst other things. I love that they went blah, 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 amongst other things. Defendants then subjected the contestants to unreasonable, unsafe, and unlawful employment conditions. On blank, defendants began the Beast Games by blank, where the contestants were held under strict control and surveillance for days on end, and then blank. During the Beast Games engagement, the on-set production staff maintained the strictest control over contestants, blank, denying them all privacy and access to the outside world. The contestants were fed sporadically and sparsely. They were not given adequate access to hygiene products or medical care, which we've heard of before. The New York Times reported that over a dozen people who participated in the first installment of Beast Games say they had not received adequate food or medical care, and that some competitors had suffered injuries from the physical challenges. Now, this is a lot of things that we've heard before, but obviously now in a lawsuit makes it really, really, really official. The female contestants particularly and collectively suffered as a result of defendants' actions. The Beast Games work environment systematically fostered a culture of misogyny and sexism where production staff did nothing while blank, and then end of sentence. Female contestants were also denied blank. Defendants dismissed blank. Defendants' violation of California law has caused common injuries, in fact, that are redressable and conductive to resolution as a class action where all of the following materials are common to the contestants. Defendants offered the contestants equivalent compensation for equivalent labor. Defendants misclassified the contestants in a uniform manner. Defendants subjected all of the contestants to the same material working conditions, including a hostile work environment for the female contestants. Defendants had improperly denied or delayed the contestants' overdue wages, penalties, and or reimbursements. The plaintiffs have filed this action using pseudonyms, I think is how it was pronounced, and applying conservative redactions that limit public viewing in a good faith effort to comply with defendants' overboard confidentiality provisions, which plaintiffs allege are unenforceable, as well as to preserve the confidentiality and privacy interests of the plaintiffs who wish to avoid opprobrium. All right. Jurisdiction and venue. Jurisdiction is proper in the Superior Court of County of Los Angeles to the California Code right here because it has general subject matter jurisdiction and no statutory. Exceptions to jurisdiction exist. The amount in controversy exceeds the jurisdictional minimum of the court. All right, now number 16. Venue is proper in the County of Los Angeles and the court because this is putative class action complaint. If I'm messing up any of these words, please. I'm not the most clever person in the entire world. Bear with me. Because this is the county in which the damages arise. Because this is the county, in which at least two of the lead plaintiffs reside, and this is the county where one of the defendants has its principal place of business. Additionally, on information and belief, defendants in each of them do business throughout the state of California, including predominantly in Los Angeles, California. All right, now we have parties. Contestant 1 is an individual and resident of Los Angeles. Contestant 2, resident, state of California. Contestant 3, state of California. 4, County of Los Angeles. Contestant 5 is a resident of the United States. On information and belief, defendant Mr. B 2024 LLC is a for-profit North Carolina limited liability company with its principal place of business being in North Carolina. It also lists its address in documentation provided to plaintiffs as, and then redacted, obviously. On information and belief, Mr. B 2024 LLC is an entertainment production company. At all times relevant, was and is doing business in Los Angeles, California. On information and belief, defendant Off One Base, the other LLC, is a for-profit North Carolina limited liability company with its principal place of business being in North Carolina. Off One Base LLC also lists in documentation provided to plaintiffs as its address as blank, obviously. On information and belief, defendant Off One's Base LLC is an entertainment production company. At all relevant times, defendant Off One Base LLC was and is doing business in Los Angeles, California. On information and belief, defendant Amazon is a for-profit California limited liability company with Los Angeles County, California. At all relevant times, defendant Amazon was and is doing business in Los Angeles, California. Plaintiffs are ignored of the names and capacities of Does 1 through 100 and sue them as Does 1 through 100 inclusive. Plaintiffs will amend this action to allege DOE defendants' true names and capacities when they are ascertained. At all times relevant to the complaint, the defendants were agents, principals, representatives, employees, joint venturers, partners, in interest and or alter egos of each other, and were acting within and furtherance of the purpose and scope of such agency, representation, employment, joint venture, partnership, corporate structure, and or association, either actually, apparently, and it goes on. Facts. The contestants engaged in what appeared to be a thorough application and vetting process for Beast Games. The contestants who were selected and agreed to serve as contestants on the Beast Games 2024 production participated in what at the time appeared to be a thorough application and in-depth vetting process. The first stage in the application process was to submit redacted. Once accepted, redacted. The contestants were required to put their lives on hold, redacted, to provide labor exclusivity for defendants in exchange for compensation and a chance to win $5 million prize on Beast Games. The contestants inserted. Why am I messing up words? I'm not clever. Reimbursable business-related travel expenses, redacted, for many which, including contestant 2 and 3, have not yet been reimbursed. All right, next. The contestant agreements that the contestants entered into a production, defendants included redacted. The contestants each entered in a redacted contestant agreement with the defendant, Mr. B, and Off One Base, jointly production defendants, in which the contestants agreed that redacted. The parties to the contestant agreement, including production defendants, also agreed that the contestant agreement would be redacted. Also, the redacted parts are so important for the sake of confidentiality on all bases, so I'm not even pissed about this much being redacted. The contestants were employee under California law, but defendants intentionally misclassified them to defendants' economic advantage, which is a really big one as well, that they're like being, this is really big. Defendants wrongfully and willfully misclassified and on information and belief continue to wrongfully misclassify contestants blank blank, although they legally can be classified as employees. The contestant agreement states on its face that contestants blank, but the agreement was in fact an employment agreement whereby defendant Amazon, Off One Base, and Mr. Beast were the actual employers of the contestant employees. Next one. The contestants were not volunteers. The contestants were promised and received compensation in exchange for their services. On information and belief, each of the defendant is a for-profit company in the business of making audio-visual programming, including the distribution on the video platform YouTube and Amazon Prime Video, amongst other platforms. The contestants were promised and received compensation in exchange for blank on the Mr. Beast production. Additionally, Mr. Donaldson made public statements online that he had unconstrained control over Beast Games, and Donaldson had established a pattern and practice of compensating everyone who competes in the Beast Games competition, win or lose, even if they completed for only 5 minutes. So this again is a really big thing because they're using things that he has gloated about online, like so much money, he has so much access, he has so much control, if you even participate for 5 minutes, you're getting paid. They're using all of him boasting to get people excited about this show against him, which is actually a really smart move. Because he's gloating to look as amazing as possible, but now they're using his words against them. They're like, well, prove it. The contestants were not working for free for the Beast Games for any humanitarian or any other public service or charitable objective. Defendants hired the contestants to work as contestants on a reality competition show. The contestants in reality were the essential labor component of the entire production, which is so true. They would not have the production without all these people that they did wrong. Their work on the show was the entertainment product that defendants were marketing and selling for public consumption and profit, which again is really great. That everything Mr. Beast was selling, these people had to make that for him. They had to perform for him. They had to do the challenges. So everything he's promoting about the show being the largest of all time, it won't be the largest of all time if it weren't for people like this. The contestants were told that if they accepted the opportunity for work for defendants, they would have to be available for, and I guess, a certain amount of time. And while they were working for defendants, they would not be able to accept any other employment. Now, that's a really big thing as well, that they're not able to accept any other employment while doing this, because that's a long time, especially if they're not being paid or paid well. Defendants compensated the contestants through the course of the Beast Games productions with both in-kind compensation as well as cash compensation, with defendants promising blank to every contestant that blanked. Throughout the Beast Games engagement, the contestants were induced to remain competing, as defendants made clear to all contestants that blank. Defendants have since requested, and plaintiffs have provided blank from the contestants to pay them and also reimburse them for their expenses. Contestants 2 and 3, this is after redaction, have to date still been not reimbursed for all out of, pocket expenses that they, had to pay for blank. And then we have something here. As a result of the combination of foregoing, the contestants cannot properly be characterized blank. Rather, they were at relevant times employees who worked at the direction and control of each of the defendants, and for these, and for the defendants' ultimate profit, which is a big thing as well, that it was ultimately for the defendants' profit. The contestants had no autonomy. Defendants exercised complete control. Contestants exercise total control over the manner, means, and timing of the work performed by the contestants by controlling essentially every aspect of their lives during the production of the show. This included, but is not limited to, requiring blank, controlling blank, controlling blank, controlling blank, preventing them from blank, blank, controlling blank, and directing blank. Whatever is included there. Doesn't sound great because they're listing a lot. When and where, defendants required the contestants be physically present on specific dates and times around the clock at locations dictated, controlled, and supervised by defendants, at which dates and locations blanked. Defendants further require plaintiffs to dedicate all of their time, and they have all of their time, to the production during the production. period, blank, requiring them to miss other work if they had other jobs. Defendant also, wanted control, blank, 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 access to personal belongings. Upon the contestants' arrival at the Beast Games, blank, 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 restricted, and we'd heard this about their stuff being taken away before. Restricted movement. Defendants corralled the contestants into tightly controlled blank. I think we can fill in the blanks ourselves. We can fill in the blanks. Where they actively supervised by production staff around the clock without any privacy. Blank, 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 blank. No contact. Defendants exercise total control over the contestants. Blank, 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 blank. See below, and then we have Beast Games rules packet. So we obviously have the rules here. Control over meals. The defendants controlled when, where, and what the contestants blank, blank, blank. Blank, 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 blank. The limited sustenance, so many big words for me. The defendants provided afforded an unreasonable and insufficient calorie intake, which collectively and in a uniform manner endangered the health and welfare of the contestants. During their time, blank, the contestants had to suffer through blank, 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 blank. When defendants allowed the contestants to have food, blank, 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 blank. Control over clothing. Defendants controlled the clothing that the contestants wore, blank, 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 blank. One day, defendants corralled the contestants, blank, 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 blank. And then we obviously have an image of maybe the clothing right here. Control over sleeping arrangements. Defendants controlled where, how, and whether the contestants slept. Contestants were filed into blank, where they slept overnight in blank, although contestant 4 blank, which included blank, 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 blank. Control over medications and recreational substances. Upon their arrival, defendants separated the contestants, blank, 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 blank. Defendants also did not allow the contestants to blank, blank. Exposed to dangerous conditions. The contestants were exposed to dangerous circumstances and conditions as a condition of their employment, even without considering whatever confidential conditions existed behind closed doors while the Beast Games was being filmed. The contestants were subjected to dangerous conditions within the course of their employment, and they're locked in contracts. As local news reported, many contestants find it was the per set conditions rather than the challenges themselves that proved to be the main difficulty. Now, that's a big thing. They're saying that the per set conditions rather than the actual challenges were the worst part. For a show with a $100 million budget, under conditions where they were underfed, overtired, and blank, and competing in stressful and exhausting challenges for cash prizes that they could change their lives. The danger, moreover, and defendants' seemingly failure to conduct background checks, blank, blank, blank. We have Rosanna Pansino's tweet. Oh my God, Rosanna is in this. I know she's in it down below with one of her YouTube videos, but it's crazy seeing a tweet in like a lawsuit. So we have Rosanna, and this is her talking about the Beast Games. On information and belief, there was insufficient medical staff to attend to potential and actual injuries during the production. There were several reports of injuries. For example, in an online article, it was reported on July 19th that in a concerning twist to the story, a source claims Desert Springs Hospital has seen countless patients today coming from Beast Games due to lack of food and water, blank, blank. And keep in mind, they were filming this in fucking Vegas. In Vegas. The hottest place on earth. Contractual control. Defendants required the contestants to sign an unenforceable contestant agreement, blank, 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 blank. And we have Rosanna Pansino's tweet literally quoted in this. We have her tweet literally quoted. I love that they're still saying Twitter in this. Ain't nobody call that X. Blank. The same agreement that blank. It also unlawfully prohibits the contestants from blank. The contestants performed work that was in the usual course and scope of defendants' business. So basically, it's very like how a Mr. Beast video is. The work for the contestants performed for defendants is not work outside of the scope of defendants' core live entertainment content business, as would be the case, for instance, for a service provider providing, production services such as a food caterer. The usual course and scope of defendants' production business has nothing to do with cooking or serving food. Here, on information and belief, the usual course and scope of Mr. Beast as well as defendant Mr. B, 2024 business enterprises is the production of live, non-scripted, or semi-scripted entertainment content whose primary focus is the contestants' reaction to extreme stress as they compete in intense and exhausting challenges to win life-changing money. On information and belief, defendant Off One Base, and Amazon are also in the business of producing live, non-scripted, or semi-scripted entertainment content. The contestants and their reactions to extreme emotional conditions are synchronum of the Beast Games productions. Their work is squarely within the usual scope of defendants' business. So I think the point they're trying to prove here is that, like, Mr. Beast should be willing and should know how to deal with this, because this is not outside of the scope of what he normally does. Okay. The defendants are not customarily engaged in an independently established business of the same nature as the work performed for defendants. The contestant work that the contestants perform for defendant is not work or services they provide to others. Unlike the catering example, the contestants do not make their living providing contestant services to various customers. Rather, this was labor the contestants provided particularly for the defendant. The contestants are, on information and belief, people from all over the world who engage in various professions, are unemployed, or are students. They are not engaged in an independent business of the same nature as the work performed by the defendant. The contestant work that the contestants perform was for defendants and pursuant to defendants' business model. The contestant work that the contestants performed was necessary to defendant Beast Games production, and the work the contestants performed was for the defendant's benefit, as the contestants provided the core entertainment value of the production. Defendants misclassified contestants blank to avoid their employment obligations under California law and to wrongfully receive unearned tax credits from Nevada. From on or about blank, the contestants worked a non-stop continuous stretch of employment for defendants during the production blank. From between blank blank, with contestants working non-stop periods of employment around the clock starting on blank blank. Reasonably, assuming a significant number of the contestants were non-Nevada residents, defendants would likely not meet the requirement for the percentage of Nevadas to the total qualified, people exceeding 60%. Moreover, defendant later required the contestants to complete blank, suggesting they intend to write off the contestants. Oh my God! This is crazy. Moreover, defendants required the contestants to complete blank, suggesting that they intended to write off the contestants' wages as expenses in an attempt to have their cake and eat it too. Oh my God. Fudging the true labor costs by labeling the contestants blank to obtain the state of Nevada tax credit. Number 2, saving money on employment wages, benefits, and employment taxes by misclassifying the contestants. And 3, deducting the contestant labors as expenses after the fact. Oh my God. Oh my God. I'm going to go grab a drink because this is a lot. So I'll be right back. Okay, and we are back. Okay, so we have this little document right here, which is showing different numbers and stuff. Defendant required the contestants to sign on basically one of these more agreements with illegal and unenforceable terms. As a condition of their employment, defendant required each contestant to enter into a contract of adhesion that was drafted by defendants. Hello, stumbled on my words there. Defendants, which plaintiffs and the proposed class were given to sign under circumstances on or about June 6, 2024, on information and belief. The application period for Beast Games opened blank to compete in the Beast Games. Defendants enjoyed superior bargaining power and used it to impose terms and conditions that are unlawful under California law, including labor code section. Defendants demanded, for instance, that blank, in violation of FEHA, in particular, this code, They also require plaintiffs to blank blank in violation with the labor code section 206.5 blank blank. The contestant agreement also purports to require blank 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 blank. Defendants unlawfully blank 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 blank. Other unlawful blank 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 blank. Defendants failed to provide a safe and healthy place of employment to the particular and collective detriment of the female contestants who suffered sexual harassment. Production defendants also failed to produce and provide a safe and healthful place of work in violation of Labor Code Section 6300, including but not limited to sections, and then it lists the sections as well as government sections. Production defendants created working conditions that jeopardized the safety of workers, including by not providing sufficient food or drink, taking away access to blank, not having adequate medical staff on site, and not providing reasonable medical care, forcing them not to sleep, and forcing them to participate in games that unreasonably risked physical and mental injury. Production defendants additionally created a toxic and hostile work environment for, in particular, the female contestants who suffered blank, as well as harassment throughout the production. As more detail below, which was not only noticed but allowed, and even blank, I guess probably like encouraged, because it's talking about the let the boys be boys, by the production defendants blank. And apparently this was allowed because of the marching orders from the top. How to Succeed in Mr. Beast Productions handbook states it's okay for the boys to be childish. It's a stupid boys club. Like, you aren't allowed to do any of this, but let the boys be boys. You know, if they want to draw a dick, if they want to fuck around, let them be idiots. If they want to draw dicks on the whiteboard, let them do it. Let them be stupid. Do everything you can to empower the boys to be boys. Help them be idiots. A document appears to be a Mr. Beast employee handbook written in first person from what appears to be Mr. Donaldson perspective, titled How to Succeed in Mr. Beast Productions, was published on the internet on August 13th. Now, we've gone through it, and it was long. By YouTube creator Rosanna Pansino. Hi, Ro! Shout out Rosanna Pansino, who alleges that she received it and confirmed its authenticity. Wow, Ro being a part of this. And her video as well, and her tweet. Wow. This alleged Mr. Beast handbook provides insights into the boys will be boys conditions that seemingly were promoted by Mr. Donaldson, which, if such Mr. Beast handbook is indeed distributed to Mr. Beast production staff, advises employees do everything you can to empower the boys, help them be idiots. Emphasis was added. And if they want to draw dicks on the whiteboard, let them. And then they have the document. So basically everything he has done himself is now coming back to bite him in the ass. So basically the document is provided right here. Helping the boys make content, apparently translated to, and then blank, we can kind of fill in the blanks ourselves. The apparent Mr. Beast ethos of helping the boys be idiots seemed to pave the way for production staff to allow blank. On information and belief, blank, 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 contestants 4 and 5's experience, as further detailed below, corroborate these reports. While the production staff initially stated blank, 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 contestants 4 and 5's experience, as further detailed below, corroborate these reports, blank, blank. Upon information and belief, production defendants knew or should have known about this behavior, blank, blank, blank. Additionally, defendants knew or should have known blank because its own employee handbook, as detailed above, laid the groundwork for this collective harassment to take place against female employees. Contestants 5 and 4 witnessed, and then we have this all redacted, by refusing to intervene, and then it's redacted, production defendants permitted to exist and fostered a culture and pattern of practice of sexual harassment, including in form of a hostile work environment where blank. Beast Games created hostile conditions where women were forced to endure the severe embarrassment and disadvantage of, and then this is all redacted, so we can only assume that whatever is here is really bad. Defendants appeared to take no steps during the course of the production to address, this is blanked out. At all relevant times on information and belief, defendants' management up to and including senior management and ownership had actual and or constructive notice that the violence and harassment detailed were occurring within the space. At relevant times on information and belief, defendants' management up to and including senior management and ownership had actual or constructive notice that its production staff was aware of, but they failed to remedy the violence and harassment detailed. Defendants made multiple false statements to the contestants in connection to the Beast Games prior to the start of the competition. Defendants falsely advertised that the competition would have 1,000 contestants, blank, and this cut the odds of winning, blank. On March 18th, Amazon shared the news that Beast Games and Amazon Studios announced the new reality show competition, Beast Games, in large print text just under a simple graphic showing Mr. Donaldson amidst a backdrop including the Amazon Prime Video and Mr. Beast logos. Amazon continued that the new show will premiere on Prime Video and is set to become the largest and biggest reality competition series where 1,000 contestants will compete for a $5 million prize. The new show will premiere on Prime Video and is set to become the biggest one where 1,000 will compete. So basically, people are competing, being like, okay, my odds are at 1,000 people, and then they get there, and it's actually the odds of 2,000 people, and 1,000 of them aren't even in the show. They're on a MrBeast YouTube channel. So, false advertising. All right. Mr. Donaldson himself also announced that same day on his MrBeast Twitter account, I love how no one calls it X, about the MrBeast Beast Games competition, stating that I'm going to be filming the largest game show in history, and they have that in bold, and releasing it on Prime Video. Over 1,000 contestants, $5 million prize, and many other world records. Emphasis added. Accordingly, at all relevant times, defendants, Amazon, Off1Base, and MrBeast held themselves out collectively as the creators, promoters, and producers of the Beast Games, and all did so in order to profit from the endeavor. Defendants wildly promoted, right through the first day of the Beast Game competitions, blank, that there would be 1,000 people competing. However, the contestants who had traveled, blank, having blocked off blank that was required by the contestants to compete in the Beast Games, only first found out the competitions, when the competition started, that blank, so basically about more people, I would assume. This did not sit well with the contestants, who made their feelings known to the New York Times reporter, who reported that right from the start, things seemed off. Some contestants that had originally been told that the competition would have 1,000 participants, this was also advertised by Prime Video earlier in the year, and then redacted. The journalist went on to add, after learning the contestants would be competing against blank, some said they felt they had been misled of their odds of winning, which is obviously true. 1,000 people versus 2,000 is completely different. Defendants misrepresented that reasonable meals would be met. The Beast Games production represented in the Beast Games rule packet that the blank would be provided by defendants. Defendants failed to mention, however, that these blanks, if they could be called that, would be infrequently provided and insufficient in the number of calories in each meal, where plaintiffs allege, by way of example, blank blank. Indeed, according to local news reports, multiple, countless Beast Games contestants were taken to the hospital, including for dehydration. It was reported that local Desert Springs Hospital had seen countless patients coming from Beast Games due to a lack of food and water, and that the production had allegedly denied food to diabetics, denied water to contestants, and at least 2 individuals, had seizures as a result. How is this show just gonna come out? Like, these people were reading about this, it has to be in the show. There's no way around that. In addition to promising contestants that defendants would handle blank blank, defendants also promised in the Beast Games rules packet that blank blank. The reality, however, was, and it's all redacted, for example, contestant 4 concluded their assignment blank, but the production did not blank until days after. Contestants opted to blank, but many were still awaiting their promised reimbursements. I guess that means they probably left or forfeited. For example, contestant 2 and 3 had submitted documentation to be reimbursed for blank, but defendants have not yet reimbursed them. The Beast Games production was so void of standards of reasonable care that MrBeast allegedly offered to cover the contestants' therapy. The foregoing acts by defendants created an environment during Beast Games that was so void of humane standards that defendants ended up volunteering to cover the cost of contestants' therapy because it was that bad. The combination of all of the foregoing created an environment in which the contestants suffered severe emotional distress. Contestants, apparently aware of the severe distress that they caused the contestants by their lack of reasonable care in conducting the production, allegedly offered the contestants therapy. Rosanna Pansino has reported on... Hey, Rosanna! Hey, on alleged contestants informing her that defendants knew it was so bad because they offered to provide therapy sessions with their own insurance. And we have Rosanna's YouTube video right here. Plaintiff's individual experiences. Contestant 1 was employed by defendants in blank. Defendants arranged and paid for contestants blank during their services for defendants. Defendants also arranged for, and then blank, 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 blank. Contestant 1 understood that they would be compensated by defendants for their services. Defendants took more than 30 days after contestant 1's conclusion of services to pay contestant 1 the promised payment. Contestant 2 was employed by defendants in blank. Defendant arranged, and then this is all blank, 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 blank. Contestant 2 understood that they would be compensated by defendants for their services. While defendants blank, blank, blank. To date, they have not reimbursed contestant 2 for blank, blank. As the date of the filing of this complaint, defendant 2 has still not received the compensation provided. Contestant 3 was employed by defendants in blank. Defendants arranged, and then whatever they arranged. Contestant 3 understood that they would be reimbursed by defendants for their services, while defendants promised blank. To date, they have not been reimbursed. They have not reimbursed contestant 3 for blank. Contestant 4, a female, was employed by defendants blank. Defendants arranged, and then whatever was arranged for her. Contestant 4 remained stuck blank for multiple days. I guess maybe stuck in the place. I don't know. Contestant 4 understood that they would be compensated by defendants for their services. As of the date of this filing, contestant 4 still has not received the compensation. Contestant 5, a female, was employed by defendants, and then blank, blank, blank. This is all redacted, obviously for privacy. Contestant 4 understood that they would be compensated by defendants for their services. As of the date of this, contestant 5 has still not received blank in compensation promised by defendants for their services. And then blank. Class action general allegations. Plaintiffs bring the action pursuant to the Cal Civil Code 382 on behalf of themselves and the following proposed class. All individuals who were engaged as contestants in the Beast Games content production blank proposed class or class for violations of the California Labor Code and the Business and Professions Code. So we have these codes for unpaid minimum wages, unpaid overtime, penalty failure to provide accurate wages, mental break penalties, rest break penalties, waiting time penalties, statutory penalties, liquidated damages, declaratory relief, attorney's fees and costs, interest including pre-judgment interest, and any other reliefs that the court may deem fair. Oh my god, this is such a shit show for Mr. Beast, Amazon, and Off One Base. That is so much that they are being hit with. Oh my god, that was so much to read out. Proposed subclass or subclass for violations of the California Government Code. And then we have the code for statutory penalties, declaratory relief, and the relief in the form of offering defendants to institute workplace reforms and training programs for employees and supervisors to prevent further harassment, including sexual harassment, as well as for punitive damages, attorney fees and costs, including interest to the pre-judgment interest and any other things that the court may deem fair. Wow. Wow. That is so much. As discovery progresses in this matter, plaintiffs may find it appropriate to amend the definition of the proposed class and subclass and will do so if appropriate. So basically, it'll be tweaked. Plaintiffs will provide more formal definitions of the proposed class and subclass when plaintiffs seek to certify the class and subclass. Excluded from the proposed class and subclass are defendants, any entities in which any of the defendants have a controlling interest, and defendants, officers, directors, legal representatives, Adam, you can say it, come on, successors, and assigns. Also excluded from the proposed class and subclass are any judge, justice, or officer who is dealing with this. All right, so basically, on information and belief, the proposed class consists of over blank thousand individuals. Jesus Christ. On information and belief, the proposed subclass consists of over 40 individuals. All right, the proposed class and subclass are ascertainable in that the members are composed of contestants who competed in Beast Games competitions, blank. The exact names of such members are identifiable, you got it, Adam, using information contained in blank. This should provide the exact number of proposed class and subclass members. All right. The claims of plaintiffs are typical in the proposed class and subclass. The claims of plaintiffs and proposed class are based on the same legal theories and arise from the same unlawful pattern and practices and violations of laws. Plaintiffs each participated as contestants in the Beast Games competitions, blank. They each sustain damage as the members, or they each sustain damages of all members of the proposed class and subclass that were caused by defendants' conduct in the violation of the law. Superiority. The nature of this action and the laws that apply to make this class action format efficient and appropriate to provide relief to the plaintiffs and the proposed class and subclass for the following reasons. The case involves big corporate defendants as well as over blank individual class action or class members with claims that with common issues of law and fact pertaining to the engagement by defendants. If each individual member of the class was required by the court to file an additional lawsuit, defendants would be able to use their vastly larger financial resources against the limited resources of these individual plaintiffs, giving them a grossly unfair advantage. So basically saying how much money Amazon and mrbeast and Off One Base have. Additionally, those who do not have the resources to even bring individual actions would be unfairly compromised. Additionally, the cost to the court system to individually hear each of these matters would be substantial. And then number 3, the establishment of common business practices or factual occurrences would establish the rights for all of the proposed class and subclass to recover on the claims asserted herein. And then finally, filing a claim with the California Labor Commission is a weaker method to address the wrongs in this action due to the limitations of such avenue, including the lack of discovery as well as fewer remedies available. Additionally, the losing party could still further continue with the trial in the Superior Court. All right, okay. Common questions of fact and law that affect the members of the proposed class include, but are not limited to, the following. Okay, we have a list, so let's go through them. Whether defendants committed worker misclassification under California law with respect to the proposed class. Whether defendants intentionally committed worker misclassification with respect to the proposed class. Whether defendants failed to pay the proposed class minimum wage in violation with the California law and other laws. Whether defendant failed to pay the proposed class overtime wages in violation of the California wage and other laws. Next, whether defendants failed to provide the proposed class with accurate itemized statements. Okay, so I'm just going to go through this quickly. So meal breaks in violation, failed to provide rest periods, failed to provide, the proposed class with the wages that they were supposed to get, entitled to relief. They're also entitled to the attorney's fees. All right. Common questions of the fact of law that affect the members of the proposed subclass include, but are not limited to, the following. Whether defendant staff committed harassment. So this is, okay, basically what needs to be proved. Whether defendant staff committed sexual harassment in violation of the California law. Whether defendant failed to prevent the sexual harassment. Whether defendant committed negligence in violation with respect to the proposed subclass, and basically is entitled to the attorney fees and costs. Absent a class action, most of the members of the proposed class and subclass would find the cost of litigating their claims to be prohibited, leaving them without an effective remedy. The class treatment of common questions of law and fact is also superior to multiple individual actions or litigation, particularly as the defendant's legal responsibility for its violations of the Labor Code, Government Code, and Business and Professions Code, in that it is conserving the resources of the courts and litigations and promotes consistency and efficiency, I guess. Plaintiffs will fairly and adequately represent and protect the interests of the proposed class and subclass. Plaintiffs have retained 4 law firms with experience in prosecuting complex litigation, which is a big one as well. California employment law and class action cases. Plaintiffs and their counsel are committed to vigorously prosecuting this action on behalf of the other members of the proposed class and subclass and have the financial resources to adequately do so. Neither the plaintiffs nor plaintiffs' counsel has interest adverse to those other members of the proposed class or subclass. Cause of action. Count 1, failure to pay minimum wage. Plaintiffs, so we've already gone through this with failing to pay minimum wage. So basically they need their compensation. The California things. This is basically like rehashing what we know. Under California law, employers are required to pay all employees a minimum wage. As of January 1st, their wage was $16 per hour for all industries. Defendants knowingly, as a pattern of practice, defendants knowingly failed and refuses to pay the minimum wages owed to them. Defendants instead require plaintiffs to work 24-hour days, 4 days, without any wages. Wait, the plaintiffs required, or it was, Wow. The defendants require plaintiffs in the proposed class to work 24-hour shift for days without any wages. Defendants, after controversy arose related to the show, claimed they would pay workers some money, but the purpose of those payments is unclear, and even if they were considered wages, would not result in plaintiffs in the proposed class earning a minimum wage. So it's basically talking about the minimum wage again, California minimum wage, and the overtime. Failure to pay liquidated damages, failure to pay minimum wages. So it's going on again about the different labor codes for minimum wage. They were not paid at least minimum wage for all the hours worked. They want to recover the liquidated damages in the amount of minimum wage and plus attorney fees and costs. Count number 3, failure to pay overtime. So it's talking about overtime. This includes pay equal to 1 1/2 times the employee's regular rate of pay for all hours and worked in excess of 8 hours in one workday, and any work in excess of 40 hours in any one work week, and the first 8 hours worked on the 7th day of work in one work weekend, and twice the regular rate of pay for any work in excess of 12 hours a day. Hours worked means the time during which an employee is subjected to the control of the employer. Plaintiffs in the proposed class worked more than 8 hours per day and 40 hours per week, but were not paid overtime for that. And it's talking about the labor code again. Count 4, sexual harassment. It's talking about the different codes, saying that this subsection imposes an ongoing duty on defendants to refrain from harassing an employer or employee on the basis of gender, sex, from creating a hostile work environment, and to prevent discrimination and harassment on basis of gender and sex. It also talks about the different codes as well that violates. Again, talking about different classes that violates, different codes, different civil codes, government codes. Count 5, failure to prevent harassment. Basically saying this subsection imposes a duty on defendants to take all reasonable steps necessary to prevent discrimination, harassment from occurring. Saying again what this violates. Different government codes. Plaintiffs request a reasonable award of attorneys' fees and costs, including expert witnesses. Count 6, negligent infliction of emotional distress. Defendants breach their duty by negligently engaging in conduct that caused and that conveyed an intent, or that unreasonably was perceived to convey an intent to cause physical harm or to place women in fear of physical harm. All right. So basically the different codes again that this violates. Count 7, failure to provide uninterrupted meal breaks. For the labor code, no employer shall employ any person for a work period of time for more than 5 hours without a meal of not less than 30 minutes. Again, the different codes that violates. Count 8, failure to provide uninterrupted rest breaks. Employees are provided with a 10-minute rest break per 4 hours of work, or a major portion therefore. If an employer fails to comply with this law, the employee is entitled to 1 hour of pay at the employee's regular rate of pay. Okay, and what that violates. Count 9, failure to provide wages promptly upon termination. Employees are entitled to all compensation due within 72 hours of the time of quitting. What that violates again. Count 10, failure to provide accurate and itemized wage statements. At the time of payment of wages or compensation, the employer shall furnish the employee with an itemized list showing the respective deductions made from the wages and what that violates. Count 11, failure to indemnify for employee expenses and what that violates. Count 11, unfair business practices, violating the above wage and hour laws, intentionally misclassifying employees, getting them to enter illegal contracts, falsely providing information to the state of Nevada to obtain unearned tax. That's a big thing as well. The thing about there only being 1,000 people when there are 2,000, which lessens their chance of winning 5 million. Count 12, false advertising, which again is talking about that it was 1,000 people for a 5 million and then it was actually 2,000. Prayer for relief, where this was declaratory relief. So it's basically reiterating what we've already read. And then we have it signed. So yeah, this is basically reiterating everything that we already know just with the codes and stuff. And then we have it signed, 16th of December. Jury demanded. Plaintiffs hereby demand a trial by a jury. Wow. On all issues so trialable. Wow. Wow, wow, wow. I keep saying it, but what's going to happen? Is this show just going to come out amidst all this? It'll be really interesting. I saw Andrew as one of the lawyers, and I went, I better not be Andrew Bratler. God. Seen too much of that man recently. It's really interesting to see how this goes. Please let me know your opinion down below of this lawsuit, and if you think how it's going to go. And please let me know what you think is going to happen with this show, and if there's going to be any statements made. I'll talk to you down below. I appreciate you being here. Thank you for watching, and wow, this is really fucked up. I'll see you in my next one. Goodbye.